5 seconds to go. Start. The Evidence Act was enacted in the year 1872 with a view to consolidate the law relating to evidence on which the court could come to the conclusion about the fact of the case and then pronounce judgment thereupon, and it came into force on 1st September 1872. The experience of 7 decades of Indian democracy calls for comprehensive review of our criminal laws, including Indian Evidence Act, and adopt them in accordance with the contemporary needs and aspirations of people. The law of evidence, not being substantive or procedural law, falls in the category of adjective law that defines the pleading and methodology by which the substantive or procedural laws are operationalized. The existing law does not address the technological advancement undergone in the country during the last few decades. The proposed legislation, namely Bharatiya Ayushman inter alia, provides as under. It provides that evidence includes any information given electronically which would permit appearance of witnesses, accused, experts, and victims through electronic means. It provides for admissibility of an electronic or digital record as evidence, and it shall have the same legal effect, validity, and enforceability as paper records. It seeks to expand the scope of secondary evidence to include copies made from original by mechanical processes, copies made from or compared with the original counterparts of documents as against the parties who did not execute them, and oral accounts of the contents of a document given by some person who has himself seen it, and giving matching has value of original record will be admissible as proof of evidence in the form of secondary evidence. It seeks to put limits on the facts which are admissible and its certification as such in the courts. The proposed bill introduces more precise and uniform rules of practice of courts in dealing with facts and circumstances of the case by means of evidence. The notes on clauses explains the various provisions of the bill. This clause seeks to provide that there is reasonable ground to believe that two or more persons have conspired together to commit an offense or an antidote and actionable wrong. Anything said, done, or written by any one of such persons in reference to their common intention after the time when such intention was first entertained by any one of them is a relevant fact as against each of the persons believed to be so conspiring, as well for the purpose of proving the existence of the conspiracy as for the purpose of showing that any such person was a party to it. It is further proposed that statements made in suits in a representative character are not admissions unless they were made while the party making them held that character, and further persons who have any property and proprietary or pecuniary interest in the subject matter of the proceeding and who make the statement in their character of persons so interested or persons from whom the parties to the suit have derived their interest in the subject matter of the suit are admissions if they are made during the continuance of the interest of the persons making the statements. Stop.